In my previous videos, I detailed the corruption of two High Court judges to conceal ongoing banking frauds. Now the question is, who judges the judges? If judicial corruption is endemic, then the backup systems become the bottleneck or focuses of corruption. In 2016, I had two appeals ongoing with the Court of Appeal for the same lawsuit. The first was against Simon Brown for 20 allegations of misconduct in his hearing, who let Deutsche Bank get away with a patently inadmissible defence, and the second against Charles Haddon Cave, who let UBS get away with a patently inadmissible defence. Subsequently, in New York, Deutsche Bank has incriminated UBS for the crimes they had alleged in both hearings. Deutsche Bank were also fined twice for money laundering, which had alleged in Simon Brown's hearing. I also notified Charles Haddon Cave prior to his hearing of those allegations. So there's no question that my lawsuit had its merits. It correctly identified that both banks were involved with the frauds alleged, and also associated criminal activities that go with destroying materials to cover up those frauds. So that when Deutsche Bank is guilty of money laundering, all the other defendants were effectively guilty of helping them get away with money laundering. Now the courts seem to be dragging their heels processing my appeal, which I started in late 2015. I was awaiting a transcript of Simon Brown's hearing that never turned up. So on the 18th of February 2016, I wrote an email to the Court of Appeal asking them what was going on with this transcript. That email arrived in the morning of the 18th of February. On the very afternoon of that day, Judge Ian Burnett suddenly closed both appeals, and his verdict was that my allegations of misconduct against both judges was scurrilous. So there was no point-by-point dissection of my allegations, no detailed analysis. And he dismissed my demand that UBS disclose its confession it made to the Department of Justice as irrelevant. So I got these court orders in the post, these verdicts, and then I got an email from the Court of Appeal, which was a transcript of judgment for Simon Brown's hearing, but not the transcript of hearing. So I knew that Burnett had dismissed 20 allegations of judicial corruption against Simon Brown without a transcript of hearing. So I wrote a number of letters to the Lord Chief Justice, showed him that Deutsche Bank was found guilty of money laundering by BaFin and the FCA, and also critically that Deutsche Bank had incriminated its co-defendants in a parallel lawsuit in New York. Now each time I mailed the Lord Chief Justice, I requested to know whether Burnett had a transcript of hearing. I wanted to know whether a transcript of hearing was ever commissioned. And the Lord Chief Justice would not answer that question, although he did claim to have taken the information I provided into consideration. Now, not answering that question is a violation of the Data Protection Act, because that transcript of hearing, if it existed, would contain data personal to me, and it would mean that the courts had data personal to me without my knowledge. It's an offence to obstruct my knowledge of whether such data exists. So if it exists, they must admit to it, and if it doesn't exist, then they must admit that it doesn't exist. That's the Data Protection Act. And if I want it, then they have to give me a copy. So this is not something a Lord Chief Justice can choose. It's not his choice to make. It should be obvious that as Chief of the Court of Appeal, it's not a question he should avoid. If one of his judges in that Court of Appeal is dismissing allegations of misconduct without proof, one way or the other, then that dismissal is completely negligent and the court is not doing its job. And also Burnett not wanting to see a confession that incriminated defendants for perjury, and it's a confession that they wouldn't admit or deny existed. You'd expect any judge to want to see that confession. The more the defendants try to cover it up, the greater the impetus to see that confession. So when Burnett covered this stuff up, he wasn't just covering up the misconduct of 2 High Court judges, but aiding and abetting fraudsters with their ongoing crimes. So the Lord Chief Justice, in avoiding answering this simple question, also conspired in those frauds. A misconduct in public office is a crime as serious as murder. It's a 20-year prison sentence, a life sentence in the most serious cases. And this man is responsible for ongoing banking frauds, and he's personally put a man in prison for the same class of crime, which is disgusting. Now, these allegations weren't just sent to the Lord Chief Justice, they were also sent to Paul Kernaghan. He's the Judicial Appointments and Conduct Ombudsman. It's his job to judge the judges. He's also known as the House of Lords Commissioner for Standards. Now, I'd sent a judicial complaint to someone called Sarah Mowell, who handled the complaint for Simon Brown QC. She basically refused to read what was in my complaint, and she based her response on what she had imagined was in my complaint. So it was completely negligent of her and also contempt for the duties of her office. So I sent a complaint about the complaints officer, and handling the complaint about the complaints officer, Sarah Moore, was another complaints officer, Nicholas Rose. Now, Nicholas Rose said he was looking into the matter. Every month he would send me an email saying he was still doing his investigations, don't worry. After 3 months, he wrote to me and basically said he's closing the investigation, nothing to see here, no evidence. When he sent me his final report, it's quite obvious he'd done absolutely no investigating. So this was a man who decided to waste 3 months of my time. And remember, with court stuff, there are time limits. So if I want to take people to the European Court of Human Rights, I've got a 6-month time limit. So these people deliberately wasting my time are trying to make me cross time limits. So anyway, I put in a complaint about this complaints officer. The head of the complaints office retired around about January of 2016, and Paul Kernaghan took over. So my complaint to him was one of his first jobs, and he basically just ignored everything. And every time I emailed Lord Chief Justice, I sent a copy to Paul Kernaghan. The Lord Chief Justice, in his replies, said that I should take my allegations to Paul Kernaghan. Since Paul Kernaghan's name was on the recipient list in my emails to the Lord Chief Justice, then both men knew that they were seeing the allegations simultaneously, and Paul Kernaghan never responded until the 5th letter, when I basically spelled out that Kernaghan was a co-recipient in the emails. Paul Kernaghan said he would be ignoring me. And Paul Kernaghan said that he couldn't believe that Deutsche Bank would launder money, even though I had showed him that it had been fined twice for money laundering, even though the FCA had accused it of destroying materials to cover up money laundering, even though the FCA had accused it of potentially laundering money to terrorists, even though that this was consistent with my allegations of money laundering that came before these fines were disclosed by the press, even though that the New Yorker had exposed $10 billion of sanction violation money laundering from Russian offices to London, which was never denied by Deutsche Bank, and Paul Kernaghan knew of this article in the New Yorker magazine, so he knew damn well that they'd been laundering money, and his attitude was that he was going to ignore me because he couldn't believe Deutsche Bank would launder money. He's the House of Lords Commissioner for Standards, And all he had to do was write a letter to the FCA or phone them or email them asking them what the fine was about. He's meant to be the man who judges the judges, and he can't be asked to phone the FCA. He can't be asked to phone the Serious Fraud Office or the Attorney General or the Justice Committee. No, he's just going to assume that Deutsche Bank have to be innocent. Even if they're found guilty, they have to be innocent. They are wronged people, and so anyone who talks them down must be a criminal who should be ignored. Well, Paul Kernaghan's the criminal. That was his first job since stepping foot into office, and he's handled it totally corruptly. Judges know damn well that if there are allegations of misconduct against other judges, they're not going to be able to judge them until a transcript of hearing is filed into the appeal bundle. And yet the judges seem to automatically assume that any allegations of misconduct must be scurrilous. That is just a way of saying judges have the right to discriminate and take bribes and be corrupt in the case where the claimant hasn't got much money. So basically, if anyone such as myself tries to sue a bank for anything, the bank just has to pay its small bribe to the judge, and the judge knows that the transcript of hearing doesn't get filed. The Court of Appeal judge just pretends that there's no wrongdoing. So I believe this is systematic bribery. I think it's on the scale of the Parliamentary Expenses Scandal. I believe that Parliament knows what's going on. Half of Parliament are lawyers, snide with them, so they've got to be in on this game. So there's my conclusion. There are two bottlenecks in the courts, two single men who hold the ultimate authority and responsibility for systematic frauds and bribery in the entire legal system. They are the Lord Chief Justice and Paul Kernaghan, head of JCO. While these two men are in office, banks are going to be allowed to get away with stealing and stealing and stealing, taking homes off people, the kind of people who pay the taxes, that funds quantitative easing, that bails out the banks for their rigging liabilities, that damage the investments of people who end up not being able to pay the mortgage and lose the houses. I don't believe that there's a single judge in England who's doing a good job. I think they're all bent. I think Paul Kernaghan's role is to identify any judge who's not part of this rigged system, and they can identify such judges by testing them for political correctness, because a politically correct judge is a bent judge. Political correctness is compensation for psychopaths. John Podesta is politically correct. Hillary Clinton is politically correct. And they will blow up entire nations and be politically correct. So these politically correct judges are bent judges. So Paul Kernaghan, his role is to detect politically incorrect judges and remove them from office, because they know that who are left are totally bent. He and his predecessors have been running this game for so long, there's probably not a good judge left in Britain.